here this afternoon in PSB docket number 8816, which is the petition of Swanton Wind LLC for a certificate of public good pursuant to 30 VSA section 248 for the construction of an up to 20 megawatt wind-powered electric generation plant powered by up to 7 wind turbines located along Rocky Ridge in Swanton, Vermont. I noticed there are many people here, so before I take notices of appearance, I just want to discuss briefly what the process is here today and who can participate. Generally speaking, this is a part of a technical hearing process, and so only the parties to the proceeding speak and are recorded on the record. Members of the public can observe and listen, but they're not necessarily, but they don't usually participate. If you want to participate in the technical hearing, you need to file a motion for intervention. And you can find copies or instructions to that on our website. It's, if you go to our main page and you look up at the left-hand side near the top, there is a link that says for consumers and the public. If you click on that link, it will take you to another page that at the very top of which is the Citizen's Guide to participating at the Public Service Board. And so if you click on that guide, it lays out for you what steps you need to take in order to participate. If you want to intervene in the case, you need to file a motion for intervention, and that guide explains how to do that. And I want to warn you, you do need to make that filing. We're going to set a schedule today. We're not going to set a schedule. We're going to discuss the schedule today, and then we'll set a schedule and send it out, and it'll be posted on our website. And you need to file your motion to intervene by the deadline that is set in that schedule. If you have any questions about this, you can contact the Public Service Board, the clerk of the Public Service Board after today to follow up on any questions you may have. So having said that, what I'm going to do next is take notices of appearance from the existing parties.
Before we do that, I just also want to add that filing a motion to intervene is not the only way to participate as a member of the public, because there will be also a public hearing in this docket, and that has not been scheduled yet. But anyone, whether they're parties or not, can come to that public hearing and make comments, and so it doesn't have to be a formal role, but there are other ways for the public to.
And you can file written comments at any time, either by paper or by email, and I think there are links on our website for filing comments directly through the website itself. The other thing I'd like to point out is, if you do file a motion to intervene, there are criteria that you have to meet, and merely filing a motion that says you want to participate isn't good enough. So you need to read the Citizen's Guide, make sure that when you make your filing, if you want to intervene, that you address the criteria specifically, and to make sure that you actually meet them. And you may or may not be granted intervention depending on whether you actually meet the criteria. So having said all that, now I guess I'm going to go to taking notice of appearance from the parties who are parties as of today.
Eric Kosicki on behalf of the Department of Public Service.
Evan Meenan for the Agency of Natural Resources.
Good afternoon, Ed Adrian for the town of Swanton.
Melanie Keene with the Attorney General's Office for the Agency of Agriculture. Dale Azari, I represent the Division for Historic Preservation. We will be filing a motion to intervene, but we have not done so yet.
Okay.
Cindy Hill, I'm here with Christine and Dustin Lang. We filed a motion to intervene about 30 minutes ago, so you may not have seen it.
I was aware of it.
Thank you.
Allison Milbury Stone on behalf of Petitioner Swanton Wind LLC.
Leslie Cadwell, legal counselors and advocates on behalf of Swanton, the petitioner. And with me at council table is Travis Belisle, and behind Travis is Ashley Belisle of the Village of Swanton.
I'm David with the Law Department.
All right, so can the people on the phone hear us?
Not very well.
All right, sorry.
This is Annette Smith with Providers for a Clean Environment, and we are intending to intervene in this docket. We have not yet filed a motion to intervene, but I will be representing the corporation.
Okay.
Taylor Newton with Northwest Regional Planning Commission. We also plan on intervening within the next week or two.
Thank you.
Parties standing in the doorway are having a little trouble hearing also. If you could speak up, I'd appreciate it.
Does this help?
Not much.
Okay.
would be helpful if you could use the microphone.
That was what I was just doing, but I'm not sure it was helping very.
That's much
Okay.
better.
The next thing we need to address is schedule. So have the parties discussed schedule?
So we've had a brief discussion about the schedule. Given the interest in the case, there are many parties. We believe there'll be other parties who'd like to intervene. So there's been some preliminary discussions. I could tell you what petitioner would like to see, just conceptually. It actually goes to something that Board Member Cheney said about the public hearing. What we'd like to do, the case has been pending for some time. It's been the subject of a lot of public process outside the Public Service Board. There was a great interest in it, as I'm sure you know, and you can tell by the number of folks in the room. We think it's helpful to have an early deadline for intervention so that we can scope out who the parties are, maybe a deadline within 2 weeks. We've already received some preliminary off-the-record discovery requests from some of the state parties. We'd like to see discovery begin as soon as possible so that we can have at least one round from the existing parties served, let's say, on November 21st, with answers due on December 21st before the holidays, and then take a reprieve so folks can have time to digest that first round and come back after the first of the year, sometime in mid-January with maybe the second round, maybe the second week, something like that that's convenient for folks. One of the things we'd like to suggest to the board that's a little different, out of the ordinary, but I think will serve the process and the public in particular much better, is if the public hearing is held after there's been more facts developed. Normally, the public hearings are held right with only the petitioner's information in hand. I think it limits the public's ability to really understand all the facts without getting information either through discovery or from the other parties through pre-filed testimony. So what we suggest is to hold the public hearing sometime before the technical hearing. That would allow the public to really have a meaningful, have a more meaningful participation because they'll have the benefit of more information from all sides.
So before the technical hearing, but after all the testimony's been filed?
Correct. And I believe in light of a conversation I had with at least one state party who has lots of subject matter witnesses with many demands on their time, after the second round of discovery, we'd like to have 4 weeks before the parties have to file their testimony. So that's the conceptual schedule, and that's about as much as I have. Other than we'd like to see the deadline for intervention be within 2 weeks. Obviously, there's interest. This is not a surprise, so we'd like to get those in and have the parties known by the end of November in time for the first round of discussion if possible.
Okay, Mr. Kosicki?
The department's developed a schedule in consultation with a number of the agencies and some of the potential interveners. A schedule. I'm sorry, I apologize. The schedule that we propose is somewhat different. I think the most salient feature that differs from the petitioner schedule is I think there's a threshold issue that needs to be addressed here, which is there's a docket, a companion docket to this review, which is docket 8571, petition for approval of Rule 4.100, power purchase agreement. The department expects that proceeding's been stayed as of December 11th, 2015, pending filing of the 248 here, which has happened, but there hasn't been any movement on that proceeding. We expect there to be a renewal of the motion to dismiss that petition. It seems to us that we should build in time for motion practice to try to resolve that issue. With the resolution of that, it has significant impact potentially on how this project goes forward. We'd like to avoid having to have a number of parties expend a lot of resources conducting discovery, review. If ultimately we find that the economics of the project don't pan out, if that motion is granted. So generally speaking, In terms of the front-end issues of the intervention deadline, we don't have any objection to having that soon. The question of whether or not to move the public hearing to a later date, we're still trying to decide whether or not that's amenable to us. But the schedule that we proposed as a first round discovery starting in early February to allow for two things. One, to try to resolve that 4.100 PPA issue, and secondly, it's a difficult needle to thread around the holidays in terms of scheduling.
So I want to make sure I understand what you're proposing. Are you suggesting that for docket 8571, which is the new 4.100 docket, that we now go forward in that docket with the stay and move forward and allow parties to file motions in that case? Is that what you're suggesting?
Right, with the hope that there would be resolution to that issue by the time first round discovery is due.
Okay, and do you see the need for a technical hearing on those motions, or is this motion just written filing?
At this point, we were just contemplating written filing.
Okay.
I'm just concerned that all of the parties to 8571 aren't actually here. This is 8816. I appreciate the department may see correlation, but I just want to raise that to the extent there's discussion about 8571, I don't think we have all the parties in that docket in this room.
Okay, I understand that, but I think that can be dealt with by asking for additional filings from all the parties on any topics we talk about here today. Any other parties have any comments?
I just have a question. Mr. Kosicki, who did you share the proposed schedule with? You talked about your fellow state agencies.
It was circulated to A&R Health, the town of Swanton, Ms. Hill. I'm sorry, I did not circulate to agriculture or historic preservation, and we shared the schedule prior to the pre-hearing with the petitioner.
Thank you.
And this is Evan Meaden from the Agency of Natural Resources. That's accurate. We had a chance to chime in on the department's proposed schedule. We're in support of the steps that are outlined in the schedule, as well as the spacing between the steps. And as far as the issue in docket 8571, the Agency of Natural Resources defers to the department. The agency has not actively participated in that docket, so we would have to rely on Attorney Kosicki's expertise in that area.
Okay, so what date are you proposing for motions to intervene?
2 weeks.
2 weeks from today?
Today.
Okay. Yes.
Thank you. Ed Adrian from the town of Swanton. So we did have some preliminary discussion on A&R's proposed schedule, and I think at least amongst who it was circulated to, there seemed to be some agreement with the bulk of the schedule. The real question was, when do things really start? And I think it's fair to say we represent the town as an entity, but there's a lot of people in the town, and 2 weeks is a pretty aggressive timeline, especially when people are thinking about cooking turkeys and things that come after that. So we feel that it's really important to allow the interveners enough time to make a decision when they don't have other things on their minds. And what we'd like to see, and we think this is consistent with the schedule that was generally agreed to, is for the intervention deadline to come after a public hearing or a work session, whatever the case may be, which would occur at the beginning of January. And at that point, we feel like it would be fair to have an aggressive intervention deadline, even a 1 week intervention with 1 week to respond. So what that would look like is the first week in January would be either a public hearing or some type of a workshop. People have a week to intervene after that, and then responses after that. And then we could pretty much go with the rest of the way that the schedule set out that the agency circulated.
Okay, any other comments on schedule?
Yes. Mr. Volz, Cindy Hill, representing Christine and Dustin Lang. I would concur with Ed Adrian's comments. We're part of discussing this proposed schedule that the department came up with, and I think from everything from February 1 on, that is the date of the first discovery round on, we're in agreement. It's this front end issue, and I would concur with Ed Adrian on that in terms of having something in January. I would also say there's a strong likelihood of a significant number of citizen interveners, and the additional time is, while it's not a surprise that it's coming, the additional time would also allow potentially the simplification of that in terms of, I know the board encourages citizen interveners to either, to clump up, to select, to self-sort, so that there are not, necessarily 127 different people each filing individually, but rather sharing, those that share common interests, being able to appear and submit those interests in a group. And while some of those discussions are, have been occurring, 2 weeks is not going to be long enough to sort that out. So I would add to Adrian's suggestion that the additional time has a strong likelihood of potentially clarifying or simplifying the procedures from there on out.
So you support early January then?
Correct.
Okay.
So I just want to respond to a couple things. First, with respect to Mr. Kosicki's assertion that a motion to dismiss will prove that the economic project and the project won't go forward, whether the project is economic or not is actually a matter for technical hearing. I don't think Mr. Kosicki can say that this project can't move forward if 8571 gets dismissed, and I think that that's his argument. So even if 8571 is dismissed, this filing stands on its own, and the economics of the project will stand or fall in this docket, not in 8571. If I don't see a reason to hold this proceeding simply so folks can have until January to decide whether they want to intervene. Again, there is, this is not a surprise. There have been plenty of opportunities for folks to make a decision. We are suggesting a more expedited process. If 2 weeks is too quick, then maybe 4. But waiting until after the first of the year for a public hearing and intervention doesn't seem very fair to the petitioner, who has spent quite an amount of money and time bringing this petition to the board. And we'd like to see at least some action on this docket before the end of the year. And we're suggesting a round of discovery, intervention and a round of discovery before the holidays to accommodate Swanton Wind's interest in moving it along. And then finally, the only other thing I would say is if folks would just ask the board to encourage parties, if they do file public comments, to copy the other parties in the case. I've had experience where the board has received comments, we haven't gotten, the petitioner hasn't gotten the benefit of it, and we lose the opportunity to respond to folks who are interested in it without that. So just remind parties to at least serve the petitioner so we know what the issues are, and if we can respond, we'd like the opportunity to do so.
Thank you. Generally speaking, if you want to file comments with the board, you can do so, as I said earlier, in writing or through our website or by email. You don't have to copy anybody else, but I think, as Ms. Cadwell pointed out, it's useful to do so. However, if you want to be a party, then when you file your motion to intervene, you have to copy all the existing parties in the case, and then every filing you make thereafter has to be copied on all the parties at the time that you make the filing. So public comments don't need to do that, but interveners and parties need to copy each other on every single thing that they file with the board. Just so you're aware. We're not going to set a schedule today. We're going to take all of this under advisement. Would the parties like some time to make a written filing about the schedule? I wouldn't mind getting actual proposed schedules from the parties.
Be happy to do so by the end of the week.
Okay. Anybody else want to? Does that work for everybody else, or would you like a little bit more time? The end of the week's okay? Or do you want more time?
I can have a proposed schedule probably.
Okay, great. Anybody else? Any of the parties want to say anything about the schedule?
A&R can make that by the end of this week.
Okay, all right, great. All right, is there anything else we need to take up today? I don't think there is.
This is Annette Smith. I have one question that I wonder if it could be discussed. and that is that on these wind project sites where these cases tend to take quite a while, there have been issues about what constitutes the commencement of construction. And because this particular project site also has other uses, I'm wondering if we could come up with some sort of established agreement on what activities will and will not take place on the site.
So there's a statute that governs this. If anyone feels that someone is acting inconsistent with the statute, they can always make a filing.
I know that, and what we've seen in the past that's happened on these sites is that it puts the neighbors in the position of, basically having to file complaints. And I think that it would be helpful to everyone if it was known in advance that work was going to be going on up at the site that was discussed ahead of time, rather than the neighbors having to wonder what's going on.
All I can say is my client isn't going to start construction of this project or site preparation unless and until a CPG is issued. That hill is a working landscape. In fact, one of the things I was going to just caution for the site visit, there are maple lines. It's a rigorous hike. You've got to duck under and over lots of lines. There's lots of stuff that goes on up there. But there's no project-related work will happen unless and until a certificate of public good gets issued. So.
Thank you. Okay, I think we're done for today. So I'd like to thank everybody for coming out, and we'll adjourn. Thank you.
Thank you.